Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Today, we're going to address the challenges of trials in sexual offences cases. Then we will examine the review that the Law Commission of England and Wales is currently conducting in relation to such trials, and finally, whether the proposed changes are justified. Article 6 of the Human Rights Act protects our right to a fair trial, which is fundamental to the rule of law and democracy. It means that defendants must be given a tangible opportunity to present their case, be able to effectively participate in a criminal trial and to be presumed innocent. The right to a fair trial is fundamental in avoiding that we send innocent people to prison. This is a principle that is not just in the interest of the accused, but it is also in the interest of victims and the community as a whole. In fact, it is so important that through its laws, the community requires that the prosecution must prove guilt beyond reasonable doubt before a conviction can be entered. Rigorous procedural safeguards have been put in place to ensure that the trial is fair, and if an accused cannot be tried fairly, then he or she shall not be tried at all. As we know, even with the application of those rigid procedural safeguards, still the system is capable of failing, so any diversion should be carefully considered. So what are the challenges in a trial related to sexual offences cases, and why some have suggested that this should be treated differently with the removal of some of those rigid procedural safeguards? So rape and sexual offences cases are very serious offences with unspeakable, long-lasting consequences for the victims. It is important that victims are heard and given a tangible opportunity to bring their abuser to justice. However, it is also important to note that the seriousness of these offences is rightly reflected in the severity of sentences that this offence attract. Therefore, the stake for the accused is indeed very high. The challenge affecting sexual offences cases is that in most cases the only evidence against the accused is the complainant's testimony. Therefore, questioning and cross-examining the complainant is the only effective way to probe the testimony and defend a sexual assault accusation. We also know that there are instances of false accusations, though in what percentage is unclear. A CPS report published in 2013 showed that over a 17-month period, there were 5,651 prosecutions for rape, and during the same period, there were 35 prosecutions for making false allegations of rape. A Freedom of Information request made to the Office for National Statistics in 2021, requesting data on false allegation of rape from 2010 to 2020, was answered as follows. We do not hold any statistics relating to the number of recorded false allegations of rape. It is possible that the Home Office may hold the statistics you require, and they will be best to advise you on this. According to the Full Fact charity, there is no way to know the true figure, but that evidence from England and Wales suggests that 3 to 4% is a reasonable estimate for the number based on malicious complaints. Nonetheless, the fact that there is the possibility of such eventuality should not be underestimated. And if needs to be relied upon, efforts should be made to be more specific rather than brushing it off with a generalized statement that they are rare. So, what is the scope and context of the Law Commission reform? The Law Commission is conducting a review of the law, guidance and practice relating to the trial process in prosecutions of sexual offences and considering the need for reform in order to increase the understanding of consent and sexual harm and improve the treatment of victims while ensuring the defendants receive a fair trial. The public consultation stage started in May 2023 and will close in September 2023. I will link the Law Commission page in the description below, where you can find more information about the consultation. There are 2 consultations papers provided, one in summary, said to be useful for members of the public who would like to share their views but may be less interested in engaging with the more detailed technical discussions and questions, and a full consultation paper which provides more detail and includes additional, more technical questions, said to be more useful to individuals or organizations who have particular interest or expertise in any or all the areas examined. The deadline for response is 29th of September 2023. After analysing all responses, the Law Commission will make recommendations for reform, which will be published in a report. It will then be for the government to decide whether to implement the recommendations. This Law Commission's project flows directly from a recommendation made in the government end-to-end rape review of the criminal justice system's response to rape, or referred in short as end-to-end rape review. The review was in response especially to the decline in prosecutions and convictions rate since 2016. This is an important point to bear in mind, as we will analyse later whether indeed this decline is founded. So do stay with us and follow us until the end. Also, if you're finding this video useful, like it and consider subscribing to allow the channel to grow and reach a wider audience. Thank you. So let's look at the scope, aim and context of the reform in more detail. The aim is said to be to 1. Increase the understanding of consent and sexual harm, and 2. Improve the treatment of victims, and 3. Ensuring that the defendants receive a fair trial. As per the context, it states that there is a wealth of evidence, especially over the last 5 years, that suggests that there is much that is flawed about the way the criminal justice system handles complaints of rape and serious sexual offences. Victims remain reluctant to report rapes. There are still concerns about police responses to victims and the investigation of sexual offences. There is an average of 7 months between reporting a rape and the police referring the case to the CPS for a charging decision. It takes on average a further 4 months until a suspect is charged. It takes 2 years from reporting to the start of a trial. The project is said to be an attempt to further counter rape myths, which have been described as attitudes and beliefs that are generally false but are widely and persistently held, or descriptive or prescriptive beliefs about sexual aggression that serves to deny, downplay, or justify sexually aggressive behavior that men commit against women. For example, that rapes are more commonly perpetrated by strangers, whilst in fact the great majority of rapes are committed by persons known to the victim, and the rape always involves physical force, when in fact rapists may use manipulative techniques to intimidate and coerce their victims. The consultation paper argues that whilst some action have already been taken to counteract such myths, such as, for example, the existence of an extensive guidance for prosecutors, pointing to myths and realities, and the ways that myths may be countered in case building and advocacy, or the Judicial College Crown Court Compendium provides an example of judicial direction to the jury on avoiding assumptions about rape and other sexual offences. However, they say this needs to be tackled on multiple fronts, including by addressing the acceptance of myths and misconception in wider society. When it comes to juries, the consultation paper states that an extensive body of research has concluded that rape myths do have effect on juries, even though this has been tested on mock juries given the jury secrecy rule. When it comes to competing rights, the consultation paper refers to a possible balance exercise to be had between the right of the defendant to have a fair trial and the right of the complainant to respect for their private life. So, what are the specifics of the proposal? In relation to access to complainants' personal records, including counselling records, they propose the introduction of a bespoke regime for access, disclosure, and use of complainants' personal records, including a complete ban on the access, disclosure, or admissibility of pre-trial therapy records. This process will involve greater judicial oversight and includes a judge applying a heightened threshold to determine applications looking at factors such as the complainant's right to privacy and wider societal interests in encouraging the report of offences and complainants obtaining treatment. In relation to the complainant's previous sexual behaviour, they propose to subject its admissibility to a heightened relevance threshold, taking into account the defendant's right to a fair trial, respect for the complainant's private life, the benefit of encouraging reporting of sexual offences, and the risk of introducing or perpetuating rape myths. Any disclosure in relation to the complainant accessing the Criminal Injuries Compensation Scheme should require permission from a judge and should be restricted using a heightened threshold similar to the one suggested for the sexual behaviour evidence. This is, they say, to counter rape myths, as the suggestion sometimes made to the jury is that the complainant's criminal allegation is false and for the purpose of financial gain. In relation to special measures, they propose the complainants in sexual offences prosecution should be automatically entitled to special measures to assist them giving evidence. For example, the use of live link to attend court and give evidence remotely, or the use of screens in court. And even the option of pre-recorded interview, examination, and cross-examination. Where the defendant seeks to present evidence that the complainant has made false allegation of sexual assault on previous occasion, the admissibility threshold should be the same as the one used for sexual behaviour evidence. Whether the complainant should be cross-examined by someone other than the defendant's lawyer, and whether sexual offences trials should take place in a specialised court or courtroom where everyone working on the trial has received specialist training in trauma-informed practices, with appropriate technology for effective use of measures to assist with giving evidence, with separate entrances and waiting areas, and with prioritised listing of cases. The aim would be to improve complainants' experience, decrease the risk of traumatization, and tackle myths and misconceptions. So what are the red flags of the law reform so far? Though the consultation claims that the proposed reform is considered in order to increase the understanding of consent and sexual harm, as well as improve the treatment of victims while ensuring the defendant receive a fair trial, it seems to really focus solely on the second point, i.e., improve the treatment of victims. In fact, it specifically states that the project will not review the laws that govern the identification of a complainant or defendant in a sexual offence case, or reform of the definition of consent that is used in the Sexual Offence Act 2003, or reform the offences in that statute. Also, and most importantly, it discounts the findings of studies conducted by Professor Cheryl Thomas, Professor of Judicial Studies at UCL and Director of UCL Jury Project. In an article entitled The 21st Century Jury, Contempt, Bias and the Impact of Jury Service, she states, "This article presents the results of empirical research conducted by the UCL Jury Project with actual juries at court from 2017 to 2019. This is the first research ever conducted with real juries in England and Wales, covering the issues on how to prevent juror contempt, whether there is juror bias in rape and sexual offences cases, which is our point here, and what the personal and societal impact of jury service is for members of the public in England and Wales. It also reveals for the first time empirical evidence for why mock jury research and public opinion polls conducted with volunteers, not real serving jurors at court, is fundamentally flawed method of understanding what real jurors think and how real jurors work. As we saw earlier, the Law Commission consultation paper told us that when it comes to juries, an extensive body of research has concluded that rape myths do have effect on juries. However, we know that this has been tested on mock juries. Now Professor Thomas is telling us that mock juries research is fundamentally flawed. She states that claims that jurors are biased against complainants in rape cases and refuse to convict defendants in rape and sexual offences cases because they believe myths and stereotypes about rape and sexual behavior were unfounded. No empirical evidence based on research with real jurors at court in England and Wales was adduced to either substantiate or refute these claims. Instead, they have relied on public opinion polls, a single study that used students and volunteers to act as proxy jurors, and anecdotal views of prosecutors in rape cases who were asked post-acquittal why they thought they did not achieve a conviction in their cases. Despite the lack of any empirical evidence from research with real jurors, these claims led to a petition to Parliament in 2018 calling for all jurors in rape trials to complete compulsory training about rape myths. The petition went on to make the following assertions. Research shows that jurors accept commonly held rape myths, resulting in many incorrect not guilty verdicts. Rapists are walking free from court, although evidence is robust. This ruins lives. Rape conviction in the UK is very low. Compared to other crimes, conviction is 21% lower. Jurors need proper rape myths training prior to and through trials. Following this petition, the judiciary commissioned the UCL Jury Project, led by Ms. Thomas, to conduct a research with serving jurors at a range of courts around the country to ascertain indeed whether claims into jurors' bias against rape complainants and low conviction rates in rape was founded. The research was conducted through an anonymous and voluntary survey of actual juries at court in England and Wales immediately post-verdict. A total of 65 discharged juries, that is 771 jurors, in 4 different court regions took part in the research. The cases the jurors tried covered a range of cases, including sexual and non-sexual offences. There was a 99% participation rate. The study found that the small percentage of real jurors who believed these rape myths amounted to less than 1 person on any jury. A second article published in the Criminal Law Review, issue 3, 2023, entitled Juries, Rape and Sexual Offences in the Crown Court 2007-2021, is even more alarming. Do you remember that at the beginning of this video, I mentioned that this Law Commission project flows directly from a recommendation made in the government's end-to-end rape review, responding especially to the decline in prosecution and conviction rates since 2016. Has there been a decline in prosecution and conviction rates in rape and sexual offences cases, though? Professor Thomas' second article provides the first detailed analysis of all charges, pleas and outcomes in rape and other sexual offences in England and Wales from 2007 through to 2021. It examines a data set of over 5.6 million charges and all 68,863 jury verdicts by deliberation of rape charges in this 15-year period. It reveals that, contrary to popular belief, juries are more likely to convict than acquit defendants on rape charges. It also shows that this has been the case for the past 15 years, that the jury conviction rate for rape and all sexual offences has steadily increased over this time period, and this is true for all nature of rape offences in England and Wales. The analysis also shows that the precipitous fall in rape charging from 2018 was part of a systemic fall in all charging in this period. That rape offences have the highest not guilty plea rate of all offences, and that juries are not always more reluctant to convict young men for rape than older men. As per the claim, the conviction rate in rape trials is 21% lower than other crimes, Professor Thomas says that the previous analysis of all jury verdicts by deliberation in England and Wales had shown a very different picture. That juries convicted in rape cases more often than they acquitted, and that the jury conviction rate for rape was higher than it was for a number of other serious crimes, such as attempted murder, GBH, and threatening to kill. These findings, says Professor Thomas, have important implications for the government's end-to-end review action plan. The Law Commission discounted this research on the basis that it was unable to shed light on how jurors deliberate. Is this a strong enough argument to discount the research? Let me know in the comments below. So, in light of this analysis, do you think that a diversion from criminal trial standards rigid procedural guarantees in sexual offences cases is appropriate, proportionate, and justified? And does it resolve the issues that it is seeking to address, such as victims' reluctance to report cases, police response to rape reports, and length of time currently lapsing from investigation to prosecution? Could the victim's reluctance to report have been exacerbated by the misleading news that rape trials are rare and tends to conclude with acquittal? Do you think that the proposed changes tend to erode the right of the accused to a fair trial by limiting the probing of the complainant's testimony to such an extent as to deprive the defendant's lawyer from asking questions? And does it carry the risk of overlooking false accusations, which may result in a wrongful conviction of innocent accused? Let me know in the comment below. I hope you have found this video useful, and if so, please let us know in the comments below. Also, like this video and subscribe to our channel if you have not done so already, so that we can invite prominent experts to elucidate some of the most problematic issues involved. And of course, join our networking hub at spokeninjustice.net to have your say as to the future content of this channel. Join us again next week. We look forward to usher you as you sit and rise in this unique trial.